the parties.
Next question comes from Terry in Joliet. You mentioned Joliet earlier. Let me give you a little background here. They're divorced 4 years, so we've got a post-decree situation here. Child is now 10 years old. The judgment calls for alternating weekend visitation. So they're going to alternate every weekend. Someone gets the child for visitation. It has not been consistent. Husband has struggled with alcoholism. So we have another issue here causing a problem in the family relationship. Wife then refuses the visitation consistently because he's not capable due to the alcoholism. He accepts his weakness, the husband does, ex-husband, and he's taken some corrective action. So he's gone to some treatment and some counseling to try and better himself through AA. He wants to get back on the schedule that was in the original divorce decree that they abandoned because of his issues. And he wants to know, how can he get back on that schedule, because his ex-wife is making it difficult now. She's not allowing the visitation, still believing that he has these issues, and she's concerned obviously for her child, who's now 10.
Well, I can tell you extrajudicial agreements, which means an agreement that changes what a court order has set in place, is really not valid. It's something the court certainly can consider. The way that a party enforces a court order, whether or not it's visitation or whether or not it's child support. Say, for example, you're supposed to pay $100 a month and you haven't paid it. Okay, so you got to force the person. You file what they call a petition for rule to show cause. If it is done and it is a verified petition, then depending upon which county you're in, because the counties are different, the court will enter a rule order requiring the other person to show cause why they shouldn't be held in contempt of court for failing to obey whatever court order that is. Now, this is very important. Whoever files a motion generally has the burden by a preponderance to prove whatever it is they're alleging. But when you do a petition for rule and the rule order issues, the burden shifts to the other person. And then if the other person can overcome it, then it shifts back to the person who filed it to be able to rebut what's going on. So
we could have multiple hearings regarding this issue of visitation,
it should just,
even though there's already a court order in place from the divorce decree stating alternating weekends.
It should just be one. You know, what probably would happen, and again, in a general sense, is we'd file a petition for rule and to hold her in contempt for not following there, because from what I've heard you, the order is still in place. It hasn't been modified.
Correct.
All right. So then they're going to hearing, and then the burden's going to be upon her to show that it wasn't willful, and she's probably going to argue that, hey, look, he has been intoxicated, I've smelled out, whatever she's going to say. But I'm guessing that there's been multiple violations of that order, because if the order generally calls for every other weekend, alternating holidays, and it hasn't happened for a period of time, there's multiple violations. And then the court's going to have to look at that and try to make that determination.
Well, there was a time here where he was not exercising the visitation due to his issues.
Unfortunately, you can't force somebody to exercise. I hear that. I get that too. The one of the spouses says, "Well, the other they're ordered to do this, and they're not." And, well, unfortunately, and it's a sad day for the children too, because they really need both spouses in their life. But you can't force somebody to do that. But he hasn't done it. That's okay. That's going to be a consideration. But the bottom line is that if somebody has willfully violated a court order, there's going to be some penalties, and those penalties can extend anywhere from attorney's fees to even some jail time.
Well, I think the ex-wife is counting on the court taking into consideration the fact that the safety of leaving the child go with the ex-husband in his condition or purported condition. Obviously, she's not conducting a sobriety test on the spot. He's not blowing into a breathalyzer, but there's been issues in the past. So I think the court, she's banking on the court thinking that, oh, she's protecting her child.
Well, but the burden's going to be upon her for that. I mean, she's probably should file a motion to modify visitation.